The entirety of the state's case is based on inferences. Inferences that are not based on reality or facts. I'll start with the last piece that the prosecutor wanted to mention. Because I did speak at the arraignment. Because I knew that the state's theory of the case was wrong at that time, just by looking at the indictment. And we didn't have all the discovery that reinforces my belief. But on the day of the indictment, we knew they were wrong. Prosecutors told you today, and I've informed them of this, so it's no surprise to the state. They want to make a big point of this cell phone somehow going missing in January. I tried to explain to them what happened, as would happen with anybody in the United States who was put on notice that they're being investigated for a crime. They would meet with their lawyer. They would meet with their lawyer, and the lawyer, if the lawyer is doing their job, would ask for any evidence that might help the lawyer put the case together. In this case, on that day in January of 2013, a lawyer took the phone of Greg Moore so they could analyze it. The state never asked for the phone. The state, up until 2025, hadn't even done a search warrant for Greg's house. They never did a search warrant for his phone. They never took some of the basic steps that you would take in law enforcement if you're trying to build your case. The most basic of things is that you would go to the defendant's house and see if there's any evidence that would be relevant to the case. You'll hear from witnesses today that they didn't even apply. They didn't even ask for that to happen. And in fact, when this case first started, they never even asked for Greg Moore to sit down and go through a lengthy statement. There was a 5-minute phone call they had with him while he was driving to court somewhere. Tell us what happened. Where were you? And that was the extent of it. So when he becomes aware that there's charges that might be coming as it relates to this other issue, of course he's going to go talk to the lawyer. Who wouldn't? And of course he's going to follow his lawyer's advice. He wasn't hiding evidence. He wasn't trying to somehow treat a scheme of deception, as the state wants to say. He was doing what any of us in this room would do on that day. That's just an example that I knew was false, that was contained in the affidavit or in the complaint in the indictment, as far as what the allegation was as part of the scheme to defraud, that I knew was false. And I have evidence between here and Dayton, Ohio, to be able to prove that that's the case. So all of these inferential things that they're trying to say that, oh, this points to Greg, or this points to this, and somehow it shows some nefarious thinking, it's just somebody acting the way they're supposed to act on that day. And the state doesn't do anything to back it up. That's just one of the examples. The other thing is they try to say that, okay, they go to his house 13 years later and sees a computer. And that computer has backup from his BlackBerry from that day. Is that someone trying to hide evidence? This is the first time they ever asked for it. They never went to his house, hey, do you have this? Can we look at anything you have here? They didn't ask his permission. They didn't do it by warrant. They didn't do it by demand from the court, order of the court. Here's a man, if you're trying to hide something, you're not going to keep something from 13 years ago that might be related to the case. The pattern's the opposite. So when we look at delay, we have to say, what did the state do or not do that would be normal in the process of events? The government's conceding today that in 2014, they had knowledge of this device, this Wi-Fi device that they're talking about that would hook into a computer. They had knowledge on that day that it existed. They had knowledge on that day about that device. They didn't get the billing records on that day, which they would have been very helpful to them, or to us, or to somebody, because it would have shown that there is no data used on the date in question. So they keep talking about things that just aren't true and want us to imagine that somehow this Wi-Fi device was utilized on what? On a cell phone? They keep talking about all these theories that can't exist. And there's no proof that it was. And in fact, the evidence would show the contrary. This device had limited or no use that month. But there is a detailed billing record that does exist for other months that would have been quite helpful in this case for the defense. Because that detailed record would have just debunked everything that they're saying about somehow on a Sunday that this device was used, when there's absolutely zero evidence that it was. The state told you today that there's the defense not prejudice. Well, let's start with the most simple thing. Well, this homicide happened on Palm Sunday. We know that Greg went to church that day. We know that he didn't set up the time for meeting with Aliza. We know that she was the one that needed to come back on that day because there were documents that were necessary. And we know from the records that Greg talked to his dad multiple times. Talked to him shortly before all this, and then later that night was talking to his dad. His dad would have been a good witness. What did you guys talk about? What was his demeanor? How was he? I can't ask that now. Because instead of, as in the normal course of events, somebody's charged with a crime and they arrest them at their house when they're in town, Greg went away for a weekend just to go see his dad, who was on his deathbed, in hospice. And they arrested him as his dad has died. And we know that there were conversations on both sides of this incident that would have been quite helpful to get through him. We can't put him on the stand now. The case is fundamentally different. We can't put the phone records from this 3291 Wi-Fi device on to this court or to the jury because we don't have it. More importantly, we obviously have the death of Sanford Sherman. Sanford Sherman, up until 2025 and really up until the time of his death, this state, as the court's aware through the search warrants that it's reviewed, this state was still asking the courts for search warrants to search devices related and information related to Sanford Sherman, indicating to the court that it had probable cause to believe that there be evidence in Sanford Sherman's possession that would point to his guilt in this matter. Probable cause of evidence of a crime that Sanford Sherman was involved in this matter, up until 2025. So for the state to say there's no prejudice of us being able to cross-examine Sanford Sherman is just ridiculous. On top of that, we have the testimony, sworn testimony, of Larry Schenker. Larry Schenker will testify today. He's been subpoenaed to testify today. And we know from his past testimony, he has stated that on multiple occasions, probably more than 4, maybe less than 10, walking on the beach, that Sanford Sherman would ask, how can a perfect murder be committed? He kept asking that question, how to do it. He kept saying, Aliza Sherman will never get a penny from this case. He told him that. He told multiple people this. We know from police records that the police had to be called out to the house many times. We know from emails that Aliza was scared of it, terrified. That Aliza's friends were terrified of Sanford. And we know that he kept asking, how can a perfect murder be committed? Larry, having some knowledge of this, given his profession, gave the answer that's completely consistent with this case. You don't use a gun to make too much noise. You cover your face so you can't be seen. You wear puffy clothes so you can't be identified. You don't utilize a vehicle so you can't be tracked. That was the advice given to Sanford. It seems to be the perfect method that was used in this case, schooled by an expert. We would want to ask Sanford those questions, but we can't. We can't because he passed away before they bring this indictment. They know that he died in July of 24, and they wait until May of 25 to bring these charges. That's prejudice. It's a fundamentally different trial when you can't put a man on the stand and see how he would deal with that question. So as it relates to delay, the only new evidence that the state has are these Verizon records that simply show that Greg got a new phone after he was put on notice that there was a problem and that he was going to be investigated. And there's a simple answer to that. He went and talked to his lawyer, who then did what the lawyer is supposed to do, is investigate the case. That isn't a new piece of evidence that blows the case open. For 13 years, it wasn't just law enforcement. You had BCI back then, BCI now. Mike DeWine's office, when he was in charge of AG's office, was involved. To show you how long back it was. Then Yost was involved. FBI was involved. None of these people ever asked for a search warrant to go to Greg's house to see if they could do something. They never asked him to come in and talk about it, except for a phone call in the beginning. Now, in the original indictment, it came out back in 2016. The telecommunication fraud count in that indictment and the grand jury testimony, which the court has, count 4 specifically deals with everything related to this case. That Greg Moore devised a scheme to knowingly disseminate and transmit by wire in a scheme to defraud. And as we found out through the bill of particulars, what they're talking about is these text messages between him and Ms. Sherman to have her brought from her house down to the office. That somehow there was some scheme to defraud by Greg Moore wanting to meet with his client to get ready for trial. But the grand jury testimony laid out all the cell tower stuff they could figure out, all the text messages, all the stuff. So the scheme to defraud wouldn't be to get her down so they could talk about the case. Obviously, the scheme to defraud was connected to the homicide back in 2016, as the grand jury testimony shows, and as the bill of particulars shows in this case. So time starts when they want to say, well, we didn't charge you with a homicide. Well, they charged him with everything but, and this was a predicate offense, but this is part of the scheme, the deception. The kidnapping count now, what is it? It's not force. It's not threat. It's by deception. It's stated. It's very clear that the kidnapping count related now is that the deception was to have her lured down, and this is the state's theory. So the 2016 case is completely related to this. And time does start at that time. There's no reason why time wouldn't start then. Any time that he was under indictment or complaint, that time it counts against. Now we signed a time waiver in this case, and we were very clear in it that we needed time to prepare for this case. There's over 250,000 pages of discovery. When we continued the trial date by joint motion, I'm not arguing anything after that date. When we asked for the continuance, when we filed motions, I think that tolls time. So I'm not arguing that those dates count in this for the speedy trial part of this. Because those were we needed that time to get ready and prepare for this case. And so that's not the issue. But prior to that request for the joint continuance, all time before that is fair game for this analysis. And in that, the statutes are clear and the case law is clear that if a significant period of time has passed, then prejudice can be presumed. In which case then, as the case law, as the court knows, if prejudice is presumed, then the state has to provide a reasonable reason for a 13-year delay in the case. So not only could it arguably be presumed, and it's been argued, and so the court can go through the records, its prejudice could be presumed. But even if it's not presumed, we have it here. This state has clearly maintained for the last 12 years that Sanford Sherman was a viable second candidate. When they hired CyberCheck to assist with the investigation, they indicated to them that Sanford Sherman was a viable suspect in this case and to investigate him. And when they found the malware on his on devices that were connected to Sanford, that were at the scene on the time, and asked the state to further investigate based on that, that was because Sanford Sherman was still a viable suspect. And but for his death, I submit he still would be. The grand jury heard testimony as to the activities of both these individuals. Clearly, having him on the stand and asking him, did you ask Larry Schenker how to commit a perfect murder? What's his answer? If he says no, he's lying. If he says yes, that's relevant to the jury. His facial expressions, his demeanor, all the things that go along with credibility, we can't ask him anymore. So just putting Larry Schenker on and say, did he ask you this? Yes, that's great. But that's just part of the story. We also have the death of a secretary. Now, she had retired before the homicide happened, but she had worked on the case. So her insights in the case and the matter, we could probably get in through other witnesses. But I don't have that witness that I could otherwise call. That means the case is different. It's augmented. There's just a little ways in which the case is augmented because of this long delay. So you're going to see that you had this issue happen in 2016. This indictment comes out. An agreement's worked out to keep Greg from going to prison, and he made the decisions he made, maybe for those reasons, maybe otherwise. But then from 16 to into the 21, 22, 23, not a lot happens. So at least for 5 years, there's just sort of this lull. Nothing happens. Cold case gets requested. The BCI gets involved again. I don't know why there was this law and why they decided to act on it at that time. They do. But again, even then, they don't ask to talk to Greg. They don't go to his house with a search warrant. So prejudice is clearly present in this case. Now, as relates to the cell towers, the court has been well briefed on all these issues. But we have in this case, we have the entry where the court found under the 2703, 18 U.S.C. 2703, that a request was made so that they could search cell tower information. And then we have an affidavit in support of a search warrant that came out in March of 14, which is just a bare bones affidavit. It just simply says that Mrs. Sherman was murdered, that she was supposed to meet with her lawyer. And then the affidavit, there's 14 or a series of phone numbers, and that's it. It doesn't say that Greg somehow did something. It doesn't even say that Greg's number is in the list of phone numbers to be searched. It's just Aliza Sherman was murdered. She was supposed to be with Greg at his office, and they were texting. And so therefore, we want a warrant. And then they list a series of numbers, Sanford numbers included, Greg's number, and then 14 or 15 other numbers. I don't even know where they're from. But there's nothing that indicates that it's anything but a bare bones affidavit. And that sort of plays out a couple of times, both in March 21st and then at other times as well. The information that they gain as a result of that is then known and shared with every single detective that's involved in this case. And the information's utilized as they try to develop and they go deeper and they look into different things in this case. So we didn't know until very recently, just a few months ago, under Chatry, that any search of cell tower data is in fact a search. The third-party doctrine no longer exists. We started to see it in Carpenter. We started to see it in Jones before that. We knew that there was, that as soon as you got into electronic data that was tracking people, that was showing the whereabouts of someone, it was getting to the point where somehow that this would be protected information. But we now know that it is protected. And Chatry has made it very clear that it is. So the court then should go back and look at the affidavits at the time to make a determination of whether or not it is a bare bones affidavit. Is there enough information there to justify the intrusion into this man's privacy? Yes or no? And the answer is the affidavit doesn't give enough for that conclusion to be made. And if it is a bare bones affidavit, the good faith exception does not apply. Because no officer would think that just saying this basic information would be sufficient. Likewise, of the search of Greg's house, finally, when they arrest him in 2025, May, they finally go and search his house. Now there's no new information as to Greg's house that somehow that would make something important or not important in this case. In fact, the evidence, if you believe the state, goes the opposite direction. They're saying that Greg's using these 13 years in his schemes to get rid of information. That he's making sure that he's hiding things, that he's getting rid of things, he's not doing things. If that's the case, then that would make it less likely that anything would be at his house. There has to be a nexus. The case law is completely clear on this. It's black letter law. There has to be a nexus to time and place for a search. There is no nexus for place, except for that Greg lives there. And there absolutely is no nexus to time as it relates to the search of his house. None. Zero. How you can get a search warrant 13 years later to search something on the speculation. Well, people keep old devices. People keep old clothes. People keep old luggage. If that's the standard for a search warrant, I would submit to you it's so watered down that there really is not a search warrant requirement anymore. If it's that, if it's speculation, well, people keep computer devices at their house. If that's enough to get a search warrant 13 years later, then there is no nexus requirement anymore under the law. So, Your Honor, after the court hears the testimony, we believe Mr. Shankar has been subpoenaed. We hope he appears pursuant to that subpoena, but he's been notified and personally served to testify today. In addition to that, a week before the homicide, so on March 17, 2013, Mary Alice Rigdon, who was a co-worker of Mrs. Sherman, heard, so she heard it that following Monday or Tuesday. But on that Sunday, a week before the homicide, somebody left a message on Mrs. Sherman's answer machine at work. And it came from an internal number, so somebody actually drove to her place of work, was able to get on an inter-office line, call her, and say, "We're going to find you," in a menacing way. Scared her. Scared her enough that she actually recorded at least a portion of that on her phone, but not the entirety of it. We don't have that recording. We don't have the recording because I don't think it was collected. We don't have that recording now to present to the jury. Clearly, that report would show that within a week prior to the homicide, a menacing person was stalking her and making threats. So this isn't just somebody just making up stuff. This is actual evidence that the jury would hear. You'd have to say that they would strongly consider it when looking at the totality of this case. And if they were to strongly consider it, it would augment their decision one way or the other. Wanting to look at Sanford in the eye and see if he's telling the truth or if he's sweating on the stand. Wanting to hear this tape and whose voice it is in its entirety. Wanting to hear from his dad to see what was his demeanor on that day. Wanting to hear from his secretary to see how much work was done and when Joe was involved, how much were they really prepared. And wanting to see the cell data from this magical Wi-Fi device the state keeps talking about. To show that show what it shows. If it shows that no data was utilized on that day, then everything the state's saying is pure imaginative speculation. And how can we have a trial where a man can spend life in prison when we have to deal with the fact that that information that they're trying to argue to a jury may not have any base at all in fact? And that's why it's fundamentally unfair to have a trial in this case, because the evidence now is not what the evidence was or could have been at that time. And because of that, we'd ask the court to dismiss this matter because of this unreasonable delay. Thank you.